As has been presented by the keynote speaker, that there are provisions in our number of laws, number of statutes about the mediation, about the alternative dispute resolution. Alternative dispute resolution means and includes not only the arbitration, it also means and includes mediation, reconciliation, and arbitration. From today's discussion of the panelists, I understand that they are mainly focusing on arbitration because understandably here we are discussing the issues commercial disputes to entrepreneurs and one banker is here. So they are highlighting this commercial disputes. The disputes which are arising out of contract. But there are number of disputes Sorry, I got disconnected. Probably I was continuing, but the viewers were not listening probably. So what I was telling is that the main obstacle for speedy and quick disposal of cases, from my experience, I can see is the procedural law. It may be with regard to Arthurian case, it may be with regard to the NI Act cases, that is check cases with checks. But today, the speakers mainly focused on arbitration, that is arising out of commercial dispute. When there is a contract between the businessman, between two parties, and if there is a provision in the contract, then you can approach the court for formation of a tribunal, or on your own you can constitute a tribunal. But the number of dispute arising out of a contract is very insignificant in comparison with other commercial disputes, like the dispute with a bank customer with its banker, the dispute with a business person with other business person keeping the check as a guarantee, if I'm not mistaken, I have taken information from Dhaka court that there are as many as 64,000 cases pending regarding checks, that is under Negotiable Instrument Act. So if the business leaders who are present today in this digital dialogue, that is the president of BGMEA and the president of Dhaka Chambers of Commerce Industry, and also Mr. Irfan Ali, who is a prominent banker, if they take an initiative to approach the legislature that there should be a provision in the Negotiable Instrument Act to make it compoundable. You see, in India, they have updated this law long ago. So if you take an initiative to incorporate this provision in NI Act, then the judiciary will be benefited a lot. 64,000 only in Dhaka court. There are 64 districts in this country. So imagine nearly 20 lakhs cases regarding checks are pending in judiciary. So how you are going to reduce the burden of the judiciary? If you increase judges numbers 100 times, then the judiciary will not be able to reduce its backlog. So I would hope on one issue. The issue is Negotiable Instrument Act. The bankers are also filing cases under Negotiable Instrument Act. So if you make this compoundable, the courts can take an initiative trial court, but the higher courts as well. I'm giving you the number of cases only of the trial courts. Then whenever any party is aggrieved by the order of the trial court, they approach the High Court, then Appellate Division. So again, the provisions which have been incorporated in the Arthur Adalat Ain, that is section 2225, it has in fact made a sort of cumbersome provisions, the rigid provision. The judge should be vested with some discretionary power, more discretionary power to deal with the situations. To this end, I would refer the law of India. The name of the law is the Legal Service Authority Act 1987. By that law, the Indian legislature have given power to the judges that they can directly intervene with the dispute. Whenever a case is filed, that may be a case with regard to authoring or with regard to NI Act or with regard to normal contract, and thereafter, whenever the other party appears before the court, the judge takes a position that I will ask both the parties to mediate or to resolve it amicably. So by that act, the judge has been given a power to directly intervene in the matter. That is by ignoring the system of adversarial system. Our judiciary, not only our judiciary, most of the judiciary of the subcontinent are conducting their cases on the basis of adversarial system. Although there is no mentioning in any law of this expression adversarial system, but the procedural law makes us adversarial system. So I would ask the leaders of this business community to approach the legislature to enact these types of law by which the judge can directly intervene into these disputes. So it's a vast topics. Alternative dispute resolution means not only arbitration, mediation, and reconciliation as well. So it would take a long time. I think I'm running out of time. So I would only hope that the competent business leaders